So I'm sorry guys. I was trying to make a video and I just didn't have it in me. It just do not feel so good and couldn't sit up here and look at screen. So I'm just gonna but this topic, you guys know, if you have followed me for a while, you know this is one of my big topics. And I know for all of you guys, my fellow truth seekers, my fellow justice seekers, my fellow faith keepers, we didn't give up when it looked kind of rough, and we were still hoping beyond hope that there was some kind of magical answer to what looked like it was going to be the end of it. So, I want to talk about my thumbnail first. So, Van Sham, because you got this one is obviously about this sham subpoena, this sham lawsuit. And I made a couple of videos a couple months ago about this as soon as I heard about this whole thing. So the van, obviously, is about these sham subpoenas and how ridiculous they are. I don't know if you guys saw this picture, but this picture was snapped, and it was kind of like, I don't know if you've seen, they've been doing these like pep walks, they're called, where they let, sorry, when I move my microphone, it's squeaky. It's on a stand that squeaks when I move it. But they notify the paparazzi and say, "Hey, we're going for a walk or we're going for a coffee or whatever," so that the paparazzi can come out and snap some pictures. And it's a long-held thing that people do when they want their faces out there, or they wanna look like they're just having their normal, happy life. But this one was particularly funny because their baby their baby is, would be like 2.5, I wanna say, or almost 2.5, and they're out with this stroller, and the joke was that people were thinking that it was empty or that it was AI or something, because when you have a 2.5-year-old baby, like, the way this stroller's set up, this is like infant stroller. So the baby faces you so you can see it, make sure it's breathing, not choking. But once they get to, like, 2, they wanna be turned around and seeing the world around them. Not only that, they've got long legs by then, and everyone's like, "Where's the legs?" And if you follow Zach Peter, he had a really funny video. I don't know if it was on his YouTube, I saw it on Twitter, but he was showing this, and he's like, "Where's the baby?" 'Cause you can't see the baby, and it even zoomed in on the reflection of her sunglasses. Sorry. And there's and it from the reflection of her sunglasses, it looked like it was empty. Like, you couldn't see the outline or reflection, I mean, of a baby in her sunglasses at all. So it was kinda, yeah, stroller gate. So you guys have heard about this. So I thought this another scam, this is, like, perfect to go with this, thumbnail because it's 2 scams in 1. But yeah, so we're talking about this sham lawsuit. So a document came kind of late last night. It was not on the regular Pacer account. This was on the Stephanie Jones, Jennifer Abel versus Stephanie Jones account. So you might have missed it if you just looked at the regular one, but it was all about them trying to get not just the subpoena, but they want the documents around this sham lawsuit. Not only do they want the documents, but they want, since this was filed in the name of Vanzan, they have every right to ask, let us know about this Vanzan company. Because if this Vanzan company felt like it had a legit cause to make a lawsuit to sue for breach of contract and to hunt down these 10 does, these mysterious 10 does, they used it to get a subpoena to access Jennifer Abel's phone. Well, there has to be some reason with the Vanzan company to have a legitimate claim to sue her. And of course we all know there isn't one, but and there's a response file today. I want to get this out of the way real quick. A ridiculous response from Team Blake saying, "Oh, we gave you that subpoena back in May," which that's news to me because every single time they've ever spoken about it, they've said they didn't get it. But It's also irrelevant because they give a list of what they supposedly gave them, that there was supposedly this sham subpoena was in it, but it wasn't all of the things that they're asking for. So it doesn't matter. Even if they gave that subpoena, here's the thing. This motion to compel is not to Blake Lively. It is to Vanzan. And they even said they want the stuff both from Stephanie Jones and Jones Works and the stuff from Vanzan because it's a comparative thing. They want to see what she got from this sham subpoena, what Stephanie has, what Blake has, and they want to compare it because their part of their claim is, like we've always said, is that Blake had these texts already long before the sham lawsuit took place. How do we know that? We know that because there's a phone call log when Leslie Sloan contacted Melissa Nathan and she said, "I've seen the text messages. We're suing you." That was the day after Stephanie took Jennifer, the day of or day after. I'm sorry, my head's a little clear. I'm kind of hopped up on Alka-Seltzer Cold Plus medicine. Anyway, it was either the day that Stephanie retrieved the phone or the next day, but it was, almost immediately. First thing she did when she got the contents of Jennifer's phone is share it with Leslie Sloan or Blake Lively or both. And we know that because of this phone call. So that's what there's so many things that they're trying to get to. It's not just the subpoena that they're asking for. They're trying to get to the root cause of all of this, like how this all took place. Because, as you know, some of these causes of action were criminal. There were 3 federal crimes and 1 state crime. Now, again, I said it before, but I want to clarify that. That doesn't turn this particular lawsuit against Stephanie into a criminal case. You can't have both criminal and civil on the same case. But what it does do is open up the fact that a criminal case, an additional case, could be filed criminally. And in that case, since it involves state and federal, it could be 2 different criminal cases because those aren't handled together either. The federal crimes would be dealt with in federal court and the state crimes would be dealt with in state court. So these are still real possibilities. And when they hired Ellen, who is the author of this motion to compel, I was so excited at that moment because she's a criminal attorney. So when she was hired, I was like, oh, they're going criminal now because they found this wiretapping and all that. So this little letter that Blake put out, and it's interesting, she files it not even in the correct lawsuit. This motion to compel was filed, like I said, in the lawsuit between Stephanie Jones and Jennifer Abel. But Blake's response comes on the big one, the Wayfair versus Blake Lively. It doesn't even belong there, but she wants it there because that's where it's going to get noticed. And like I said, she says, oh, we handed over that and we handed over this, but completely leaves out that that's not what they're asking for. And they're not asking for it from her. They're asking for these things specifically from Vanzan. So it's not good enough. Like her letter today was just a waste of time. And you'll see why as we go through this motion to compel. So it's a bit of a bomb drop, really, and I was so excited to see it. And if you followed me for a while, you know how much I hate these Dear Judge letters. To me, they're so informal. I like a nice formal filing. It's got the adversarial caption, and it's got the title of the document. But this one I didn't mind because I was so happy with the contents. So it starts off saying what they want. They want production of documents from non-party Vanzan. So this isn't, thanks CJ, that was fun. I love making the thumbnails. This is kind of like the Jennifer Abel and Stephanie Jones. It's a third party sort of thing, a little off to the side. And, like, we don't have enough defendants and plaintiffs in this case, let's but it's necessary in this case. So they want a production of documents, not from Blake. They want it not from Stephanie. They want it from Stephanie. They've already asked it of Stephanie, but they also want it from Vanzan. So, and then we see there's been an exchange of emails. There's even been a Zoom meeting trying to get these document requests narrowed down because there's obviously been something they've been fighting about. As we know, we only get this information when there's something they're not agreeing on and it has to be brought to the court's attention. So who knows how much of this is going on behind the scenes that we never get to see. But paragraph 2 comes in really strong with words like sham action and shell company. So we know the story. We know that Jennifer Abel was in her last week of employ, but she still had a couple more days left. We know that her phone was seized and that it was a company phone, but she had her personal things on it. And we know that Stephanie, sorry, I'm gasping like, I can hardly breathe. But anyway, so we know that she was supposed to turn the phone number over because the phone number belonged to Jennifer. It was one she'd had since high school. And so Jennifer Abel went straight to Verizon, waited for Stephanie to turn the phone number over, which she never did that day. And it took her a long time. I think she said months to get that worked out. And then when she did have the phone and she signed everything, when she got her new phone and got the number released, she signed everything on her new phone. And she thought mistakenly that once she signed onto that one, everything on the old phone would be signed off. And probably never dreamt that Stephanie had gone through and extracted everything either. But the bad part about it is that this phone continued to be accessed, they say, all the way up to January of this year. And that there were things like her iCloud being accessed. So even if this was a company phone, Stephanie had no right to get in there and access all of her things. Anything that was personal or private, she had no access, no right to go into those things, especially something like an iCloud. And to continue, because the iCloud never belonged to the company, that's personal. And then to continue getting into it into January is just, it's crazy. So, so that's the background. But anyway, and she was able to, well, what they're saying is happened, and I truly believe this with all my heart, is that the stuff was already handed over to Blake, and Blake wanted to legitimize it because she wanted to go to the New York Times with her story. So that was the birth of this sham lawsuit, and it was called Vanzan versus the 10 Does. So this is a shell company that's owned by Blake and or Ryan. Now the contract itself, the lawsuit itself, there's so many issues with that. There are no factual allegations. I love their use of the word bereft. I had to highlight that in green. But how do you have breach of contract? And then there are does, are the defendants. How do you have a contract with someone and you don't know their name? I mean, that's absolutely impossible. So everything about this lawsuit is just not on the level. And that's what we've talked about so many times. I put back on the community tab some videos I made 2 months ago that show the proper way to do a Doe lawsuit in New York. And this is not it, by the way. And spoiler alert, this is not it. But besides them doing that wrong, there's just so many things wrong with how they did this. So they say that Vanzan had no discernible need for the information that Jones obtained. And that's why I love the word bereft too. That's why, see, I can't peek at your comments because then I forget what I'm trying to say. This is why they need the stuff directly from Vanzan, because they want Vanzan to prove, why did you have the authority to file this lawsuit? Why did you have the authority to get this information from Jennifer Abel's phone? You didn't have a contract with her. You know, how on what authority did you get this subpoena issued for this information? And then it mentions, of course, that once the subpoena was returned, this action was dismissed without any other proceedings. And this is the important point that I've always said, without ever having requested the assignment of a judge. And that's really important because in a Doe lawsuit, you need a judge. That's the requirement in New York law. Not to repeat too much of that, but if you didn't watch that, in my community tab, I linked 2 videos that explain all of that. I just don't have it in me to repeat it all tonight. So this subpoena is what opened the door for Stephanie to extract the stuff from Abel's phone. But again, she'd already done that. But they know this, and I like this little sentence because it says, Lively produced at least some of the information during discovery, confirming that the Sham Vanzan action was successful in facilitating the transfer of Abel's data. And how do they know that? Because this was prior to the filing of Lively's claims against Abel and the Wayfarer parties. She used this stuff back for the New York Times article. She used it for the CRD complaint. So at least by then she already had it. That was long before a lawsuit. And they're trying to prove she had no authority to do that. The other thing is it was just so broad. We saw one of the first things that happened in this lawsuit had to do with the phone subpoenas that Blake was trying to serve upon the Wayfarer parties. Now, she made it ridiculously broad. Why? Because she already had a ridiculously broad amount of information, and she needed a cover. She needed a subpoena to legitimize the illegitimate stuff that she already had. But then that got messed up when Wayfarer quashed the subpoena. They said this is way too overbroad. We don't have to do this. And the judge actually, surprisingly, granted that motion to quash. And so then she was sitting there like, uh-oh, I've got all this information, but the legit subpoena doesn't cover it. So there's so many reasons that they need this information, and they need it from Vanzan. So here's another really important point. Lively's lawyers have publicly acknowledged and defended the Sham Vanzan action and subpoena. And that's the brilliant thing about not just Blake, but her attorneys. None of them can just shut their mouths. They just run their mouths all the time. And it's actually been great because there's so much out there available to get to prove the case. And this is just one of those many, many occasions where they spoke, and we'll see that article in a moment, to Dateline, and completely defended this lawsuit. They called it, they said there's nothing untoward here, just conscientious and thorough investigation. They said that it's common tools that are entirely lawful and appropriate for pursuing claims and uncovering the identity of unknown perpetrators of unlawful activities, but that's not what they used it for. So he goes on to say these tactics are hardly common or appropriate. This lawsuit is a sham intended to obtain information irrelevant to the proceeding in which it issued, which was the Vanzan lawsuit. Most egregiously, the purpose of the subpoena was either to obtain privileged and confidential information, and this is important, without notice to Abel, or to cover up Jones' prior disclosure of Abel's confidential and privileged information to Lively before the subpoena was even served. And then such an important point, Abel remains in the dark as to whether Jones actually produced documents in response, or if that was merely a smokescreen. So, did they get the subpoena and Stephanie just handed over what she had already extracted? Or, or what she chose out of what she had extracted? Was there a whole new phone extraction? What was it? This is all important to how they're going to proceed from here, because I'm thinking they're proceeding criminally. I mean, all the signs point to that. That's just my opinion. But to me, this kind of very specific gathering of this information does seem to point that they are gonna pursue this criminally because they're trying to distinguish what was gotten where and by whom and by what means. So these are really, really important details. And it's interesting because one of the things that Wayfarer tried to use previously was the crime, um, oh, my brain not working. The crime fraud exception. And the judge said, "You haven't proven a crime took place." Well, here you go. I think they're on that now. So now originally, Abel asked for 11 categories. Now, as far as I'm concerned, I would be like, I want all of this. But she's been very reasonable. So while they were meeting and conferring, she was so reasonable. She agreed to withdraw 6 of her 11 original requests. So she withdrew over half of what she originally asked for. I mean, she is bending over backwards, and she shouldn't have to. She was completely violated. I feel so bad for her. I can't imagine what it must feel like to have, because our entire lives are on our phones these days. All of our private, intimate conversations with our partners, with our parents, with our siblings, with our best friends, our banking, our photos, there are so many things on our phones, like, literally our whole lives, and she's still being so reasonable. She's like, "Okay, it's too much. Okay, I'll cut it more than a half." So she narrows it down to 5 requests, and we'll go through those in a moment. But what happened? Vanzan rebuffed. So after all the things they did to this woman, they are still being nasty. They're still playing hardball. They're not ashamed. They're not sorry. They're not decent. They refused to produce any of it. And so that's what brings about this whole motion to compel. And that's why Blake's letter fails so miserably, because she just ignores all of these things that were requested. And I want you to think for a moment about what kind of reaction Blake would have if somebody had her phone like this. We saw just text messages between her and Taylor. We've seen the extent she's going through to try to block that. And that's just one person in her context. Imagine what she would be doing if someone had taken the entire contents of her phone. And then it shows how this rule, everything that we go through, I've talked about this a lot, every part of it we go through is governed by a specific rule. And so the specific rule dealing with this is Rule 26B1. So then they cite some cases that support their side of their request by these cases. So sorry. Sorry, I'm gonna take a drink real quick. So this narrowing brought it down really, really reasonably. Now they also talk about them accessing her cloud, and that's just wrong. There's no way that that's okay. And this is where we come into the criminal stuff. Abel's activities after Abel departed from Jones in violation of the federal wiretapping statutes. So this is why I really feel like this is going to go to criminal charges, and I with every bit of my being I want it to. Um, the requests are also relevant to Abel's allegation that Jones relayed the data she obtained from Abel's phone to Lively. This is what I mentioned earlier, prior to service of the subpoena, and that the Sham, Vanzan action and subpoena were devised to allow Jones to hide behind an allegedly lawful subpoena. I saw someone, yeah, Rico, it maybe I'll cover that at some point. about Rico and the possibilities of that, but I am very, very excited. So everyone was discouraged, and remember I told you guys just keep the faith, don't get discouraged, just wait. I knew that an attorney and everybody, I feel bad, I've said it before, like Brian Friedman gets all the credit. There's actually a really good team. There's Mitchell, there's Kevin, there's Jason, now there's Ellen, and they're a good team, and they're not gonna just slink away and say we lost. So I knew something bigger was coming. They were not going after this stuff and going after Taylor's text for no reason. It's just that sometimes these things take time, and you know how I feel about the judge. Yeah, gamer girl, the judge is an issue. The judge is an issue. I believe this. I'm not intimidated by his title or his status. I call people for how I see them, and a lot of his judgments are questionable. He appears very biased. There's something wrong there. So when you're dealing with I mean, they're at the mercy of this judge at the moment. So what they have to do is devise some way to get this settled, and they're probably going to have to go around him. It's probably going to have to be an appeal of some sort. It could be a writ of mandamus, for example, that, something that's going to take this to a higher court and out of his hands if he's not going to be reasonable. If I'm, a part of me is like just ready for him to look at this and say, "Oh, it's okay." You know, really. But it's not okay. And I think that that's what they're preparing, and it took some time, and they couldn't give any, they couldn't leak anything about it to let us know, but I knew that there was something bigger going on behind the scenes, and we just had to wait for it. So, um, let's see. So the things they're asking for, this is another reason why Blake's letter it just fails in so many ways. They didn't just ask for the subpoena. Here they're asking for Vanzan's organizational documents, documents identifying its owner, um, Lively and or her proxies, what they own or control of Vanzan. Um, were they participants in the scheme? Because you know what? If they're participants in a scheme that's found to be criminal, guess what? Blake and Ryan could be facing criminal charges as well. If they were part of this, it's their company that has nothing to do with this. And it was used to get this sham subpoena to do wiretapping, to try to cover wiretapping. This is serious now. And, you know, like I said it a couple of months ago when we talked about this, when I very first saw the criminal charges on when they added Stephanie Jones as a third party, is the first time we saw that. And I said back then, this is their company, and if they had actual custody of these ill-gotten documents, there there could be criminal. So yeah, Taylor's criminal lawyers. Yeah, this attorney used to work at Venable, where that's Taylor's law firm. We recognize that name from the subpoena that was served for Taylor initially. So, this is a really big deal, and I mean, this is what drug me out of bed because I was so excited when I saw this last night, but there was just no way I could do it last night. I was so excited, and I felt so sick, and my fever was like 102 last night, and that's with medicine. But, I get like extra I'm emotional anyway, but I get extra emotional when I'm sick. So I was watching Lauren and Omar, and that when this came out, it came out while they were alive, and they started reading it, and I'm just sitting there just bawling because I feel like this is finally a step towards these people getting justice. Not just Justin. I say that all the time. We need to stop saying Justin. We need to say Wayfair, because there are so many victims here. And what happened to Jennifer Abel is just atrocious. Just I mean, when you put yourself in the position of someone having your phone, just how violating that would be. Roses, that's the is it the letter I'm talking about? The letter that says, "Oh, we already gave you the subpoena in May?" Let me know if that's the same one. Um, is that's the one I've been talking about. It's like it's useless. Yes, you know how I feel about 47.1, and Omar and I are gonna have a conversation about that. I've already spoken to a friend of mine who's kind of a famous attorney, don't wanna spoil anything, he might come on my channel at some point. But, yeah, this if you look at the an and I did an episode about it. If you look at the anti-SLAPP laws and how this very court that they're in has ruled on them, they do not allow them. And I know that they're trying to say 47.1 is not anti-SLAPP, but the reason it wasn't allowed in this very court, and it's a higher ruling than Judge Lyman, so he can't rule differently, is because there are things like fee shifting, things that are procedural, and those are all governed by federal law. State law cannot override that. So, anyway, yeah, I don't wanna get too distracted on that topic. We'll come back to that again. But anyway, so we're back to, the law about Jennifer Abel meeting the threshold that's necessary for them to compel this discovery. And then they talk about some of the excuses that Vanzan has used to try to refuse to produce these things. One of them was undue burden, which is absolutely ridiculous. There's 2 whole documents filed in this case. 2. And they're, a few pages. How is that undue burden to go through? This company only has 1. I think it's a purchase and delivery from the UK to, New York. It's the only action it seems to have ever taken. So how hard is it gonna be for them to go through and get these documents? Seriously, it's some kind of sham company, but I do wonder, like, when they hired that CIA guy, I thought all along when Blake and Ryan hired him, you don't go that far for something like this. I wondered, like, if there are things that they needed to keep hidden, and very often those things can be financial. When you make the kind of money that they make, especially like Ryan made that huge sum all at once of like 300 something million. Now, a lot of that was in stock from what I understand, but you get socked with a huge tax bill. So, people donate to things or find some way around, you know, sometimes. Now, I'm not saying that Blake and Ryan did this. I'm saying this is a reality that happens when people, because getting hundreds of millions of dollars all at once. Hey, Mark Walker, I haven't seen you in a bit. He's he's my very first member, my very first super chat, one of my very first subscribers. Longtime, longtime friend of the channel, friend of mine. But now I lost my thought. See what you did, Mark? Now you're in trouble. So a lot of times what they'll do is they have these little companies, and they find a way to have some kind of financial loss to help eat up some of the taxes that they owe. So, could this be something we find? It's possible. Please don't say, "Oh, Cassidy said, they did this." I'm not saying they did this. I'm saying when you have a bunch of odd little corporations like this that you don't use realistically for anything, they're always suspect. So, that might be why they're trying to hide all of this. They don't want to come forward with documents about this company, or they could just be being the butts that they are. So, they're saying, undue burden was one. The other one was that the documents can be obtained from a party to the action. So what they're saying is, first you should go to the parties of the lawsuit. Why are you coming to third parties? Yeah, the butts. Why are you coming to third parties? But they already explained that. They said, yeah, we can get it from this, but we want it from Vanzan. Vanzan had the gumption to file this lawsuit. They should have to provide their documents. They got themselves involved. Nobody just said, "Hey, this is a company of Blake and Ryan. Let's go subpoena them." Van Zandt got involved first, and now they've got to answer for why they got involved. It's that simple. And then, so they're saying, these fail. These reasons for not having to provide these documents fail. And then in a footnote, they give us a third reason that they tried. They say that they objected on attorney-client privilege, work product, and confidentiality grounds. Um, we've talked about those before recently. But guess what? They already have protective orders, and they have an extra one in this case. Remember, we have the attorney's eyes only protective order that they asked for. This is the perfect time to use that. So you cannot use this as grounds for not producing the stuff on this subpoena. Sorry. Ah, sorry, guys. You were waiting for chicken butt. I almost said it. See, there was a long pause because I almost said it. But I'm like, I don't want to overuse the chicken butt. But okay. So then as far as that third party thing, there's no rule that says that you have to exhaust, all parties, so you go to a third party. But also they want, like I said, they want it from Vanzan as well. Someone else said chicken butt. I love that. Every time I say, guess what? I always want to say chicken butt. So it came out in one of my videos not long ago. Um, so, but another thing they have to say about that is that they did request the bulk of the documents from Jones back in March, 3 months ago, but Jones has failed thus far to comply. So all of their excuses absolutely fail. And then they go into this part that I've been saying. It's imperative that she obtain documents directly from both Vanzan and Jones to confirm what the actual subpoena requested, what was produced, and what communications Vanzan had with Jones about the Vanzan action. Finally, Vanzan's organization and ownership documents are not available from Jones, but only from Vanzan. So Jones has some of the things they want, but she doesn't have all of them, especially these organization and ownership documents. And sorry, you stuck your company out there and filed a lawsuit in its name. Now you got to show us about the company. It's that simple. Yes, Pam. Boone Hall, that was another, there's a bunch of these weird little companies, and that's always questionable because we know what Blake's official company was. It's Blakele. That's what she signed her contract for the movie under. So we know she has an official company. So what are all these weird little companies? It's not her Betty Boo's. It's not her Blake Brown Hair Care. It's, what are these little weird companies? And so they, in the letter saying this court should order Vanzan to comply and produce the requested documents without further objection or delay. And they do, because they need these things for like depositions. And all of that comes to an end on August 14th. That comes up really fast. So, why would they need AEO for this information? Well, if it's a legitimate company, which this is not, things like your sales and salaries and things like that, that would be in your information, and that would be confidential. So they could, but here's the whole point is that this AEO is available to them. So there's no reason to say we can't provide this because it's confidential. Then mark it AEO and go on. That's what I think, could be a possibility. I won't be, let me say, I won't be surprised if that gets discovered. Tax evasion. I won't be surprised at all. Okay. All right. And so also that came with this letter was a memorandum in support of it. It included some exhibits, and One of them was the original subpoena that they issued to Stephanie Jones, and they issued this one back in April, and it was supposed to be turned over by May. Now, these are the things that they originally had asked for, all of these 11. I'm going to move my mic. It's probably going to squeak. Sorry. I got to shift position. Sorry. So originally they asked for 11 things, and they've narrowed it down to only 5 now. And they're so reasonable. I would have demanded all 11. If you had my phone in my whole life, you're giving me everything I want. But, that's not always possible, especially with these kind of people. But the first one is documents sufficient to show your organizational structure, current or former officers, directors, management personnel, identities of any subsidiaries, parent corporations, and affiliates, as well as their relationship to you. Again, this is a company that saw fit to file a lawsuit. Now you got to reveal yourself. 2 is one they dropped. This was all of the company's bylaws. So all their amendments, restatements, revisions. They probably don't even have one. I would guess they don't even have this. 3 is articles of incorporation, including original filings, amendments, and restatements. Sorry, I've got a cough a moment. Sorry. All these sounds today, sorry. Then we have number 4. Now this is one of the ones that stayed included. So they want documents concerning shareholders, their ledgers or registries, records of stock issuance and transfers, lists identifying your current and former shareholders, including their ownership percentages or numbers of shares left, and records of shareholder meetings, resolutions, and votes. Again, this can get them in trouble if there's anything unsavory in here. And, I can imagine that's why they don't want to show it. The next ones are ones that were eliminated. We have number 5, copies of all corporate resolutions or consents and meeting minutes concerning meetings of your board of directors and officers. I would venture to say they probably don't have that. Number 6, any operating agreements, shareholder agreements, joint venture agreements, or similar governance documents concerning your operations. 7, any filings with state or federal agencies reflecting corporate governance, structure, or ownership. Number 8, documents sufficient to identify the Doe defendants against whom you filed the lawsuit. This one was eliminated, but this is interesting because when I did those episodes about how a Doe lawsuit is supposed to go, that's one of the things. Once you know the identity of the Does, you add them to the lawsuit, and that never happened. And now the next 3, those are ones they're still asking for. All documents and communications concerning the lawsuit, communications between you and Stephanie Jones, Jones Works, or anyone acting or purporting to act on their behalf. Number 10, a copy of all subpoenas served by you in the lawsuit. And this was interesting to me. We know about this lawsuit, but what if there were others? Wouldn't that be interesting if there were others somehow? There were none filed because these were the only documents that we found. But number 11, all documents produced in the lawsuit by third parties pursuant to any subpoena. These are all very reasonable requests. They have legal grounds to request all of these things. There's no reason that this is being refused. Also exhibits, we had the summons and complaint. Then we have the where they dismiss the lawsuit after they got what they wanted. This is the file showing that these are the only 2 documents that were ever filed. And there we have Samantha's name. You're famous, Samantha. Look what you did. And then we have the deadline article where they were so bold as to go in and say, oh, these are common tools. These are entirely lawful. These are appropriate. We have nothing to hide. It's so funny to say we have nothing to hide, and yet they won't turn this stuff over. It looks like you have everything to hide. If you had nothing to hide, you would turn this over. It's been months now. Khaleesi. Shout out to Samantha. You become a household name, Samantha. And yeah, that's it. That's it for tonight. So thanks for putting up with all of my nasty sounds and grossness tonight. I tried really hard to make a video. I couldn't sit here that long. It's so much faster to just get on here and talk with you about it. And but yeah, the takeaways are this is very exciting because it looks like, at least in my opinion, looks like this could be definitely going criminal. And they're just getting all the information that they need in order to do that. It would affect Stephanie, it would affect Jones Works, and it could possibly affect Ryan and Blake as owners of the company that filed a sham lawsuit, and also them holding on to information that was got by unsavory methods. So anyway, don't lose faith. I saw some people, were not happy about Brian and thinking Brian wasn't doing enough. He's doing everything he can. He's got a lot of obstacles in his path, but he's got to do this a certain way. He's got to do it the right way, and he's dealing with a judge that does not like him. And so it's just stuff we don't know what's happening behind the scenes, but I think he's going to blow this up, and he's going to blow it up big. So thank you guys. It's not the stroller. Yes, the stroller. The stroller gate. Where's the baby? You guys got to see Zach doing that. It's on Twitter. It's so funny. He just keeps asking, "Where's the baby?" So anyway, thank you guys. Have a wonderful night. And I'm working on Brett and Aiko's part 2. I've got most of the slides for that, but I just got to feel good enough to sit up here and get it finished, put together. But I'm hoping to get it put out by tomorrow or at the latest Friday. So keep an eye out for that. Anyway, thank you guys for all of your feel better. Yeah, it's about time for my next dose. And then I'm going back to bed. So thank you guys so much. Have a great night.